hand over the microphone to Learned Senior Advocate, Mr. Oyetola Atoyebi, SAN. Please a round of applause for him.
Thank you very much. Good evening, everybody. This was a set of by the way. We'll be talking about political party processes, internal democracy, candidate selection, and pre-election disputes. As you all know, there are so many, and thank God my brother of the silk, my senior brother is here, Alasan, Senior Advocate of Nigeria. He has spoken on behalf of the chairman, and a few of the issues he had mentioned, of course, touches on some of these things that we're going to be discussing today. I know that a lot of us will have different opinions and different agitations as regards the forthcoming election, but of course, the chairman has said all of us should calm down. Thank God we also have the fact that the law corridor is also going to send their communique after this process. I know as a matter of fact that there are a number of cases in court as we speak, particularly in the Supreme Court, that has to do with a number of the political parties. Of course, at the Federal High Court also, there are a lot of cases as regards deregistration of some political parties, and of course, some pre-election issues are already coming up. Thank God we have the fact that the party guidelines has come up, and of course, by May, there will be so many activities, and I'm sure that all that we'll be listening to would eventually be something as regards politics, and of course, INEC has the focal point. So today we'll be talking about internal democracy. 3 segments. First, the internal democracy of political parties. And number 2, candidate selection. We're about going through that process. And of course, we have the pre-election disputes. On internal democracy, one of the major sections that is different from the one from the Electoral Act of 2022 is Section 84, which regulates party primaries and nomination of candidates for elective offices. We also have Section 29 of the Electoral Act, which is also retained in 2026 Act, which requires political parties to submit and publish candidates' particulars for public scrutiny by INEC. And of course, beyond this, limited provisions. Both the 2022 and the 2026 Act do not regulate broader internal party matters, such as party leadership selection processes, internal disciplinary structures, decision-making mechanism within party organs, and of course, membership participation framework. But as you know, as a result, political parties continue to operate with significant internal autonomy in accordance with their constitution. And the Supreme Court, like you all know, is very particular about the internal democracy of political parties. Based on a lot of the case laws that we have in Nigeria, you will notice that what is most important for the courts is that there must be independence of the political party to be able to regulate their internal affairs. Even with this autonomy, you would also know that the Electoral Act 2026 strengthens compliance expectation in relation to electoral-facing party activities. And that's what's important, particularly candidate nomination and submission processes. By reinforcing adherence to lawful procedure under Section 84, like I mentioned, and ensuring transparency through public disclosure requirements under Section 29. Although the Act still respects the constitutional autonomy of political parties, it introduces compliance-based expectation that requires parties to adhere strictly to democratic norms, just like the chairman has mentioned. They expect that parties should self-regulate themselves and they should comply. Compliance is key. A key implication of this reform is that internal democracy is no longer merely a political ideal, but a regulatory expectation. tied to electoral legitimacy, political parties are expected to maintain credible membership registers, conduct transparent decision-making processes, and of course ensure that party rules are followed consistently. You will still know, like we've been seeing, a lot of challenges still remain. The balance between party autonomy and regulatory oversight is delicate. Excessive interference by INEC could raise constitutional concerns, while weak enforcement could render the reforms ineffective. Furthermore, of course, like you know, a lot of parties are already complaining that INEC is causing troubles for them, of course, and thank God the chairman has said their doors are open to them. Let them come for clarifications, and they can deal with these issues. And of course, like you know, some of these issues might end up in court. Excessive interference also affects a lot of things, while weak enforcement could render the reforms ineffective. Furthermore, entrenched political interest within parties may resist reforms that threaten existing power structures. I believe strongly that INEC on its part has been trying its best to ensure that a lot of the issues that we faced in the past general election, they're trying to resolve it. And sometimes I tell people that we should give them at least some room to improve. We should give them at least some room to better their processes. And we should also, whenever we have discussions like this, we can give our own candid opinion to them and give them advice that perhaps will help a lot of the things that we're doing. From a neutral standpoint, strengthening internal democracy requires not only legal provisions, but also cultural change within political parties. Political parties, we cannot all be pushing all the problems to INEC. Political parties also have their problems, and they should be able to fix them. Apart from maybe one or two parties that are not having issues, I think most of the other parties that we have in Nigeria have issues. And political parties should also try as much as possible to resolve their issues. And because we're talking about internal democracy, justice is not only meant to be done, but should be seen as done. And that is the message for the political parties, so that there will not be interference. And once we don't have interference, I'm sure that the political landscape will get better gradually. Transparency, of course, from the political party, accountability, and inclusiveness must become institutional norm rather than mere statutory obligations. We also are all aware that there's a lot of hijacking going on right, left, and center. And one will only think that how would it now be possible for these matters not to end in court if some parties or people are feeling that their rights are being trampled upon? Some of the questions that perhaps will be agitating our minds today, are taking the luxury or liberty of mentioning them, which we're also going to discuss, is how can INEC effectively monitor internal party processes without undermining party autonomy? It's one of the big elephant questions in the room. What mechanism can ensure transparency in party leadership selection? There's a lot of issues as regards party leadership selection, which we all can see, and perhaps through this dialogue we're having today, we might be able to proffer some suggestions on how to resolve those crises. One of the other questions is, how can ordinary party members be empowered to participate meaningfully in decision making? Number 4, what sanctions should apply where parties fail to comply with democratic standard? And last but not the least, are there comparative best practices from other jurisdictions that Nigeria can adopt? Interestingly, for the lawyers in Nigeria, when it comes to election issues, they're always very happy. So I'm not sure this solution, lawyers in Nigeria will be happy to hear them. But of course, on a practical note, we need to be able to begin to address those issues. The second aspect of our discussion, before I pass on the mic to Prof, is on candidate selection. In the Electoral Act of 2026, it introduces a significant reform under Section 84(2) by eliminating indirect primaries. Of course, what we have is now direct primaries or consensus arrangements. And of course, the problem we will have there now is this: how do we not have a situation whereby some people are imposed on others? Part of the questions that we need to actually deal with. These reforms is intended to enhance transparency in candidates' emergence. There's always a problem around the transparency as regards a candidate emerging. Then, of course, the reform is also meant to reduce manipulation associated with delegate system, and of course promote broader participation of party members in candidate selection. And I honestly must commend INEC and all the stakeholders as regards this Electoral Act. It has tried to streamline and reform a lot of issues. Of course, we know this act is a work in progress. The whole process is a work in progress, and we should help by giving our suggestions as we move on. INEC is further empowered to, of course, monitor party primaries, ensuring compliance with statutory requirements. This represents a shift from passive observation to more active regulatory oversight. But I'm sure that there will be a lot of personnel needed by INEC to be able to do some of these functions, and logistical issues might also happen or arise. In addition, Section 29 of the Electoral Act 2026 retains the requirement for submission of candidate particulars, but reduces the timeline from 180 days to 120 days before the election. While this streamlines the electoral timetable, it also compresses the window of scrutiny, objections, and resolutions of dispute. My worry, by the way, is the time frame to be able to resolve these issues. I know, as a matter of fact, that our courts are congested, judges are overworked, issues here and there, and the time frame to be able to meet with the timeline is also going to be a challenge. Despite this improvement, several issues remain, and I'm going to highlight them. Consensus arrangements may still be abused to impose candidates without genuine agreement. Is going to be a problem, big problem. Monitoring by INEC may be limited by logistical and capacity constraints. The shortened timeline may increase the risk of rushed or unresolved issues. If you noticed, I think a few days ago, if my memory serves me right, a party had written to the Supreme Court that they have a judgment pending, and they want their judgments as soon as possible. 3 parties within 3 days. So those issues are there, that timeline, and of course you still have so many other disputes. I mean, these judges are human beings like all of us, and they are even advanced in age. You cannot kill them, you know. But on the other side, the Nigerian citizenry, they want a quick, fast result. As to their issues, political parties want as far. In fact, for political parties, they want their issues, their disputes to go from the Federal High Court, Court of Appeal, and Supreme Court within a day, if possible. But of course, it's impracticable except we amend the Electoral Act. And some of these things are the things we're going to discuss today. From a neutral perspective, like I mentioned, the reforms reflect a clear attempt to institutionalize transparency in candidate selection. However, their effectiveness will depend on strict enforcement, genuine party compliance, and active oversight by stakeholders. Some of the questions we also would consider is, does the removal of indirect primaries significantly reduce manipulation in candidate selection? We will see it as we move on. How can consensus arrangements be regulated to prevent abuse? Thank God we have chairman of a political party here. I'm sure I will push that question to him.
Is the 120-day timeline sufficient for proper scrutiny of candidates? How can INEC effectively monitor primaries across all political parties nationwide? What role can civil society and party members play in ensuring transparent candidate selection? And these are some of the questions that we have to consider while we're thinking about this candidate selection, because candidate selection is very important, and that's even one of the foundation or the bedrock of the general election. Okay. The last part or last aspect is the pre-election dispute. Under the Electoral Act 2022, pre-election matters formed a significant portion of election litigation, particularly in relation to issues arising from party primaries under Section 84 and submission of candidates, particularly under Section 29. These disputes, which fall within the scope of pre-election matters, are defined under Section 285(14) of the Constitution of Federal Republic of Nigeria. Of course, these were frequently adjudicated by courts. While this provided a mechanism for accountability, it also led to delays, conflicting judgment, and judicial congestion. One of the matters that we did in the last election cycle, the courts had to sit on a Sunday because the matter was going to expire the next day. Sat in the morning, they told us to come back around 7, and they gave that judgment. And how can we continue to do this in this country because of the timeline? And the timeline is quite very, very key in as regards these things that we're doing. The Electoral Act 2026 introduces important changes that indirectly affect pre-election dispute by Section 134, which narrows the grounds for election petition to issues of non-compliance and majority of lawful votes cast. And those are the only two grounds. Of course, matters relating to candidate qualification are effectively excluded from the post-election litigation. This shifts greater emphasis on resolving such dispute at the pre-election stage. Furthermore, Section 29 continues to provide a legal window for challenging candidates' particulars prior to the election, thereby reinforcing the importance of pre-election litigation. And I feel that from next month, Alassane, I'm sure that there will be a lot of matters. In fact, I hear that the matters are already coming in, by the way. Not primary, yes. Of course, from most of the parties, yes, most of the primaries are going to be conducted from next month. Additionally, stricter timelines for electoral processes mean that pre-election disputes must be resolved more quickly. While this promotes efficiency, it may also strain the capacity of courts and litigants. A major concern is access to justice. While the Act imposes financial penalties for improper petition in post-election matters, there is a risk that similar deterrent effects may discourage legitimate pre-election claims in procedural orders if procedural orders become too stringent. From a neutral standpoint, like I always mention, the reforms shift the focus of electoral justice from post-election to pre-election adjudication. This has the advantage of resolving disputes before votes are cast, thereby reducing uncertainty. However, it also increases pressure on the judiciary to deliver timely and consistent decisions. A few of the questions that we would also take would be, how can courts ensure timely resolution of pre-election disputes without compromising justice? Does the restriction of post-election petition grounds increase the importance of pre-election litigation? Do they shift the battleground from post to pre now? Are current judicial timelines sufficient to handle the volume of pre-election cases? Over the last election cycle, how many matters? Over 1,209. We're expecting maybe about the same or slightly more.
How can conflicting judgments be minimized in pre-election matters? Well, I feel that when we get to the judiciary aspect, because sometimes you get a judgment, particularly in some of the courts,
what is happening in the north is entirely different from what is happening in the center, and what is happening in the south is entirely different from what is happening in the east. And everybody, we still don't have a refined or a central system. And one of the judges had mentioned at a forum like this and said, how will I be aware of the judgment of my brother justice in an area when I don't even have time to watch the news? And I'm not meant to be influenced by another person's position. It's entirely the way I view the case. And so we're still having issues as regards conflicting decisions, and we also need to perhaps suggest some of the things that we need to do. Lastly, should alternative dispute resolution mechanism be introduced for intra-party conflicts? The challenge is, will anybody be willing to even sit down and consider alternative dispute resolution? Well, maybe negotiation is also a form of it, because they will end up negotiating anyways. But in real time, most parties prefer to go to court. I'll yield the floor to my brother Silk, Professor Meyaki, for your own comments and contribution.
Leonard Silk,
thank you, everybody.
Just a few seconds. Leonard Silk. Thank you, Leonard Silk Atoyebi. A round of applause.